Thank you very much. In case many of you don't know me because I'm new to Europe, I'm coming from working for UNHCR in Africa and Asia. So it's a bit daunting for me to be here with so many experts and renowned experts on asylum law and refugee protection, but it's also a great pleasure, and the discussion is being fascinating to me so far. So as I said, I haven't been in this environment for a while, but that being said, being here does remind me back in the days when I started my career in international human rights law, working as a research fellow at the Faculty of Law of the University of Oslo, and that was the time when the Convention on the Rights of the Child was being adopted, and I was working on that. So you'll get to know me a bit better. I hope you don't mind if I share you a personal story in this respect, because after working for a few years as a researcher, I decided that I really wanted to go to the field, and I thought that UNICEF would be the best fit because I had, been working on children's rights. So I called them up, and the first question they asked me was, "Well, are you a Watson engineer?" And I said, "No." And then they said, "Are you a health worker?" And I said, "No." And they said, "Well, what do you do?" I said, "Well, I'm a lawyer, and this new Convention on the Rights of the Child has just been adopted, and I'm sure I can help UNICEF in this respect." And sadly, UNICEF at that time didn't want any lawyers, and the only organization that did want lawyers was UNHCR. I saw an ad in The Economist, and they said they were looking for lawyers, so I applied, and they sent me off to the biggest refugee emergency at that time, which was the mass influx of the Rwandan refugees to Tanzania. But I have to say that even at that time, when I was monitoring the border between Rwanda and Tanzania and trying to ensure that those fleeing the genocide in Rwanda, made it to Tanzania, and I was far away from courts and research institutions, the law was the very basis which I was engaged as a protection officer and which UNHCR is engaged. And this continues to be the case. However, it's obviously stating the obvious to this group that nowhere is asylum law as important a tool of refugee protection as it is in Europe. And since recently joining UNHCR's Europe Bureau, I have really been impressed with the important legal safeguards which have been achieved in Europe, and which are reflected in the still newly adopted recast Common European Asylum System. There's clearly now a strong legal framework on which to build protection efforts and which courts will develop further. Can you hear me? Should I turn this down? That being said, in the short time I've been here, I have also seen real suffering among asylum seekers and refugees in Europe, which has not only surprised me but also saddened me. And I have noted not only gaps and disparities in the implementation of legal standards, but also sometimes a formalistic and rather than a protection-oriented attitude to finding some of the solutions for the challenges today. So what I'd like to talk about today is some of the challenges to the Common European Asylum System that UNHCR still sees, and how the arrival in Europe of people from Syria, so clearly in need of protection, has accentuated some of the gaps and shortcomings in the national, but also the European protection regime. And to put this in context, I would like to begin with a very short video, 4 minutes, which visually illustrates the situation of new arrivals to Bulgaria. So.
In a disused school in Vraždebna near Sofia, Bulgaria, the corridors echo with loss, frustration, and anger. Syrian refugees, 400 of them live here in a purgatory of flooded floors, broken toilets, insufficient hot water, and overcrowded rooms. Zarbor studied engineering in Homs until he fled with his family into Turkey. In September, he ended up in Bulgaria.
My family is 6 persons, and my aunt's family, and the other families, there's also Syrian people, and some Afghanian people. There are 4 persons. So the number is 17 persons.
17 people in this room.
His grandmother, Amina, complains that so many children are sick, and so is she with a bad back.
We ran away from the war and are now in the same situation.
If things don't improve, she says she'd prefer to return to Syria. Things, in fact, are improving slowly. In a room where bedsheets become flimsy walls, Latifa, a mother of twins, confirms it.
Before, they are the situation very bad. The toilet is very dirty and no radiator and no hot water. But now it's better now. Not very, very better, but now it's they have changed. Yes.
On a recent visit with the EU Commissioner for Humanitarian Aid, Kristalina Georgieva, UNHCR's High Commissioner Antonio Guterres promised that his agency would help Bulgaria and urged the European Union to do more as well.
We cannot forget that these people have suffered enormously, and it's totally unacceptable that they go on suffering once they reach the European Union. There is a European responsibility to receive these people and to give them the kind of hospitality and solidarity they dramatically need.
In a meeting with refugees, the High Commissioner heard their anger and frustration.
I need paper, I need students, I need basma, I need go work, I need go business, I need go
We all together working to try to address the very serious problems that you have. UNHCR, the UN Refugee Agency, is going to start also working in Bulgaria in support of the government to be able to support Bulgaria.
For the Syrians here, the schoolyard here has become their world. Each receives just over $1 a day for food, transport, and medicine, and many fear to meet local people.
Some people in Frigidina think we are not good people. So they think we are killing and we are make problem here, but we are not like this. We want pieces. Not we want to kill anybody. We want just people in here in Sofia feel us how we are, how our situation, how we are scared from the war. I want to live a good life, just good life. No war, no more war.
More help is coming from the UNHCR, but much more is still needed. For these people, this is not war, but it is not peace either.
Okay, so that the High Commissioner just went to Bulgaria at the end of November, and after that decided actually to launch an emergency operation in Bulgaria. So quite unique in the European Union that UNHCR is going and supporting the Bulgarian government, but indirectly providing assistance operation. And it's also not surprising, I think, after you've seen this video, that on January 2nd, UNHCR issued a paper entitled Observations on the Current Situation of Asylum in Bulgaria. And in this paper, UNHCR recommends a temporary halt to transfers under the Dublin regulation to Bulgaria due to gaps in the protection system of such magnitude that there is a risk of inhumane or degrading treatment for asylum seekers. The risks flow not only from the deplorable reception conditions, but also from gaps in the procedures, making access to protection a real challenge, both when the initial claim is made and upon a Dublin transfer. This is not the first time that UNHCR has highlighted that the situation in a given member state is such that UNHCR advises against transfers. In 2008, UNHCR issued a paper with our position on returns under Dublin to Greece. And in 2012, UNHCR found that transfers to Hungary of asylum seekers who had transited through Serbia would place them at risk of refoulement as they did not have access to a merits procedure. Furthermore, courts throughout Europe, both regional and national, have found that it would be not permissible to transfer individual asylum seekers, not only to Greece, but also to other European countries based on their individual circumstances. Three important observations can be made about the common European asylum system in relation to these situations. First, that despite what must be considered overall as a strong legal framework, there are still such significant gaps in the implementation in individual member states that asylum seekers, time and time again, are at risk of inhuman or degrading treatment and that their need for international protection is not secured. Second, that the ambition set out in the Treaty on the Functioning of the European Union, requiring the Union to adopt measures on asylum in accordance with the 1951 Refugee Convention, providing, among other things, for a uniform status of asylum valid throughout the Union, a uniform status of subsidiary protection, and common procedures for the granting and withdrawing of these status has not yet been achieved, even with the important steps in the new legislation to ensure this. And third, that European states taking part in the Dublin regulation are intricately bound together in the efforts to ensure that the standards set out in the common European asylum system are met in each and every state. UNHCR therefore underlines that the common European asylum system requires both member states and the European Union to continue these efforts. At national level, all states must implement fully the agreed standards and afford protection to those who are found in need. They must also work together with the institutions to think ahead on ways to ensure a truly common procedure and a uniform status. As such, it seems clear that close cooperation and support to each other remains essential. There are, of course, already provisions in the European instruments which support this. The recognition in Article 80 of the Treaty of the Functioning of the European Union that the principles of solidarity and fair sharing of responsibility shall guide the asylum area, the potential for alternative arrangements in case of mass influx as set out in the Temporary Protection Directive, the newly applicable Dublin III Regulation Article 33, which sets out the early warning mechanism and potential for support, and of course the important role given to the European Asylum Support Office. Despite these provisions and the existing legal framework, the increase of arrivals in Bulgaria from a yearly average of 1,000 to more than 9,000 in 2013, mainly Syrians, has led to such suffering and hardships for asylum seekers and such a dire situation that UNHCR felt compelled to respond. It seems therefore clear that more can be done to better apply the tools of the common European asylum system in situations of a significant increase in arrivals into a member state to prevent the suffering of asylum seekers and the emergence of serious protection gaps. I would now like to turn to look at the situation of Syrians in Europe. As we all know, we are now 3 years into one of the most destructive crises of our time. More than 2.3 million Syrian refugees have fled Syria and have registered with UNHCR, among them also an increasing number of Palestinians. While a relatively small number of Syrians have arrived in Europe so far, many European states have seen a considerable increase in applications. The arrival of large numbers of Syrian asylum seekers, so clearly in need of international protection, has starkly highlighted where gaps in the common European asylum system persist. Some important issues have arisen concerning access to territory, access to procedures, the lack of good quality data on asylum, poor reception conditions, and the use of detention, problems concerning the application of the Qualification Directive and the status granted. In addition, of course, are issues not fully addressed in the common European asylum system, such as that of penalties for illegal entry and the support to find durable solutions, whether that is for a future in Europe or for voluntary return at some point. Access to protection, whether on the territory or at the border, including the transit zones for those who seek asylum, is clearly guaranteed in the Asylum Procedures Directive. Despite this, UNHCR has had reports of pushbacks in the border at some of the cases. And I would add, because this was also raised earlier today, that monitoring these border areas, Turkey, Greece, Bulgaria, is a priority for UNHCR role in relation to our supervisory responsibilities under the Convention. And we're also really working very closely with our NGO partners, civil society such as ECRA, because we really hope to enhance our activities in this respect. However, there are also difficulties of actually making a claim even when one reaches the European Union, as been highlighted recently in Bulgaria. The important role courts can play on the question of access to protection was amply evidenced in the 2012 judgment of the European Court of Human Rights in Hersi and others in Italy, where the court found that Italy's obligations under Article 3 of the European Convention on Human Rights were engaged in the circumstances of that case, whether or not the applicants had expressly requested asylum. Equally important was the court's finding that Articles 13 and 3 require notably access to a remedy with automatic suspensive effect, including at the border, in the case of Gebre Hemedine and France. That a sudden increase in arrival of asylum seekers can create pressures on the reception capacity of a member state is evident. The recast Reception Conditions Directive goes a long way in ensuring adequate minimum standards. Despite this, and as the recent situation with the arrival of many Syrian refugees in Bulgaria has shown, these standards are not always met, and asylum seekers are not guaranteed a treatment which respects their rights. In fact, we have seen in the landmark case of MSS and Belgium and Greece, the European Court of Human Rights ruled that the material destitution of the applicant in Greece was so dire that it amounted in and of itself to inhumane and degrading treatment. UNHCR has also found this to be the case in Bulgaria at present. Detention of asylum seekers is another area of particular concern to UNHCR. It was heartbreaking to hear testimonies of Syrians who just escaped the bombings and the war in Syria to arrive in Europe with the hope of getting protection and experiencing compassion, only to find themselves in disbelief in their new situation as inmates in detention. UNHCR is pleased that the new asylum acquis has strengthened the safeguards around detention of asylum seekers. However, the real safeguards will be in the implementation and in the willingness to find alternatives so that those in need of protection are not exposed to the degradation of life in detention. Here again, the role of the courts will continue to be of crucial importance. UNHCR has also highlighted that in the context of Syrians coming to Europe, that there is a greater need for better asylum data. UNHCR is of the view that a more effective common European asylum system will require better, timelier, and more transparent asylum data. This will be essential for the application of Article 33 of the Dublin Regulation, but also more widely to ensure correct application of the acquis. While statistical data can never tell us the full picture of a situation, it allows for the type of analysis required to take early corrective measures, whether to prevent overcrowding of reception centers, incorrect use of detention, meeting the needs of vulnerable groups, or improving asylum adjudication. Okay. A final word, perhaps, on the adjudication of claims and the application of the Qualification Directive. This is an area where international refugee law and UNHCR's expertise is most developed and where we have invested significant resources in working with states on ensuring high-quality decisions. The recast Qualification Directive has, in our view, clarified some important areas, but there still is, of course, divergence between UNHCR's position and the final text, most notably in relation to exclusion. Another important area that requires some further guidance is that of credibility assessments, and UNHCR has recently published a large-scale study looking into ways in which credibility is assessed in select countries, and I think we bought a few copies of that study. And this relates, I just picks up to where Dr. Costello left off, and that is what is less developed in the case law concerns a priority given in the Qualification Directive to refugee status over subsidiary protection status. While there have been significant and defining judgments concerning the interpretation of Article 15C, the relationship between refugee status and subsidiary status has had less attention. And already we published a publication that Dr. Costello also mentioned called Safe at Last, in which we looked at the practice in 6 member states in relation to the application of Article 15C to asylum seekers from Iraq, Afghanistan, and Somalia. The research revealed wide divergence in rates of recognition at first instance of refugee status under the 1951 Convention in the 6 countries studied, as well as the use of Article 15C. This issue is also at play with regards to Syrians arriving in Europe. UNHCR has found that many Syrians seeking international protection are likely to fulfill the requirements of the refugee definition contained in the 1951 Convention relating to the status of refugees and the corresponding provisions of the Qualification Directive, since in many cases their well-founded fear of persecution will be linked to one of the Convention grounds. However, Eurostat figures for the first 3 quarters of 2013 show that around 60 to 63% of Syrians are given subsidiary protection and only 24 to 29% refugee status at first instance. We welcome, however, that in Ireland, all claims from Syrians decided in 2013 were grants of refugee status. The correct application of the Qualification Directive, and in particular the status granted, is not only a matter of principle or legality. It can significantly influence people's lives, as the rights attached to the status vary significantly from country to country, including the right to family reunification as regulated by the Family Reunification Directive. This was illustrated in a recent case which came to UNHCR's attention, in which 3 young Syrian refugee boys were detained in their first country of asylum, unable to reunite with their father in the European Union because he had subsidiary protection status and did not fulfill the additional income requirements for family reunification that this status required. It's difficult to understand when we're struggling every day to provide life-saving support to Syrian refugees in so many countries, when we know that those who flee are likely to be refugees, and we urge states to use all tools, including family reunification, to provide protection, we come across such heartbreaking cases. So these are the gaps I have seen since arriving in Europe and working mainly with Syrians. I was going to quickly highlight the tremendous achievements of the Common European Asylum System and close. How many minutes do I have? One. Okay. You all know the achievements much better than I, so maybe I'll just switch to a few closing remarks. But before I do that, I have to refer to the importance of the EDAL case law database, because this database provides a very important tool to practitioners for their engagements with courts. And there will be no doubt that courts will be instrumental in developing the Common European Asylum System further, and for this we all need the necessary tools. As such, UNHCR sees the development of jurisprudence as one of the most important next phases of the Common European Asylum System, and the EDAL case law database will make an important contribution in this respect. I'd like to end here by mentioning 5 main areas where UNHCR sees the need for strengthening the Common European Asylum System or developing it even further in the future. 1 is the further development of the legal standards as formulated by the courts and their implementation. 2, increased practical cooperation amongst member states to ensure a much more harmonized approach and adjudication of asylum claims in Europe, which will be challenged not only because not all member states have signed up to all instruments of the Common European Asylum System. In both these areas, UNHCR would also welcome a much stronger gender perspective. Research done by UNHCR on the prevalence of victims of female genital mutilation amongst asylum-seeking women and girls who have not claimed asylum on these grounds have highlighted important gaps in relation to identification of gender issues. Looking ahead, more thinking could be put in relation to a better defined or agreed understanding of the principles of solidarity and responsibility amongst EU member states. This should reflect both an absolute necessity of all member states to commit fully to the international and regional protection regime, but also a clearer understanding of the common responsibility to ensure international protection of all those in need who come to Europe. Again, another issue is the focus on solutions for refugees, which looks not only at protection as the granting of a status and rights, but more holistically on how those who join our societies can contribute actively and constructively when rebuilding their lives. And finally, the need perhaps for a more longer-term vision and thinking about where protection sits in relation to overall migration and labor market needs. UNHCR will of course remain engaged in these important areas and lend our expertise and presence in this work as we go forward together, and we must succeed because we owe it to Syrian refugees like Zabor, Armenia, and Latifa. Thank you very much.